Hey, good morning, Sarah Boone friends. Hello, yes, I come to you with a wet head this morning. Hey, Toxic. Hey, Sherry. Good morning, guys. Good morning, good morning, good morning. Ay, ay, ay. All right. So, again, today we are simultaneously streaming. It's not too bad. I mean, it's a little bit like because I can't really commentate on both. But yeah. So, hey Henny. Good morning. Good morning. All right. So, Boone is back on trial today. Expecting closings and everything to happen today, to be honest. I'm expecting for everything to happen today. So, I'm ready to get started. Are you guys ready? I hope you're having a fabulous morning. I hope your coffee is strong. My coffee is strong. Well, not super strong. It's regular strong, but it's low. It's low. So I'm going to have a fill up soon. All right, let's get started and see what happens this morning. If you're watching over on the Ferris trial stream, they're supposed to be going on a field trip today. So I'm kind of really excited about that. I'm excited about that. I'm wondering how Boone's attorneys are feeling. Do you think that they're feeling defeated, or do you feel like they're feeling like they've got this in the bag? Like they've got this in the suitcase. Ha ha ha. That was funny, not funny, huh?
This morning, state, or is there anything we need to address before?
Okay.
I do.
Good morning, ma'am. Could you state your name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
Ms. Boone is seated at counsel's table, buttressed by her attorneys wearing a black suit and pink blouse. All members of our jury
Wayne.
are present this morning. State, or is there anything we need to address before we
Good to
bring in
see
our
you.
panel? Defense, anything we need to address?
Yes, Judge, I intend to introduce these two exhibits that have already
Oh my
been,
God.
stipulated to. One is what's their name?
Right now, their ID is AD.
Oh, I bet he's introducing those two
Statistics identification AB, Judge, which is the order
orders that he talked about yesterday. I forget.
2019. It's a no contact order.
No contact orders.
And identification, AC.
They have to know she's toast, right?
Dated June the 19th, 2019, and then I'd like to introduce them into evidence, and then I'd like to hand publish them to the jury.
Okay.
And let them look at them one at a time. And then I believe we're going to rest our case, but at some point, I guess you would excuse the jury because Sarah Boone needs to be questioned about.
And there may be additional motions to be addressed at that time. So yes.
Do you want to do that now before we bring the jury in?
I don't have a problem with that. If you want to rest now, subject to those being entered and published, and we can address any motions, the court has reviewed both of the no contact orders. And that way we don't have to do a in and out, and I can colloquy Ms. Boone at that point in time, and we can proceed with the state's rebuttal case.
Subject to those, the introduction of those two exhibits just mentioned, the defense would be resting our case at that juncture.
Okay, all right. Yes, ma'am. Okay, I've been advised by the courtroom deputy that juror wearing badge 130, seat 10, cannot stay past 5:30 today. So just be advised, and we'll use our time accordingly.
That one is the 6th.
I don't believe so. Give me a moment, and I can check.
The jurors like, I can't stay past 5:30 today. So that means if they go to deliberate, they're not going to be able to stay past 5:30 today. I don't think that they would be going into deliberations
That
today
is an
anyway,
alternate. It's alternate seat 4.
Thank you.
because he said yesterday that they were going to do their charging conference today. So, yeah.
Defense, do you have any motions?
Just out of abundance of caution, I would read new or motion for judgment of acquittal pursuant to defense resting. I'm going to do that now while the jury is still out. I don't have any additional arguments other than what was made the other day.
Okay, thank you. Any other additional argument, Mr. J?
Just that at this point in time, the standard is whether or not a reasonable trier of fact could find the defendant guilty, and there is sufficient evidence for that to be sent to the jury.
Okay, thank you. The court recalls the arguments that were made after the conclusion of the state's case, both from the state and the defense. The court finds that a reasonable juror could make a finding of guilt on the elements of the sole charge in the information beyond and to the exclusion of each and every reasonable doubt. For those reasons, the renewed judgment of acquittal is denied. Ms. Boone, I have a couple of questions to go over with you, ma'am. You've been previously sworn this morning. Your attorney has indicated that all of the evidence and testimony of all witnesses in your case have been presented to the jury, with the exception of the 2 no contact orders pre-marked as AB from June 16, 2019, and the no contact order of June 19, 2019, pre-marked as AC, which once the jury comes back in, he will enter into evidence and produce them to the jury for their viewing. Are there any witnesses that you wanted to call that your attorney failed to call?
No.
Is there any evidence that you wanted your attorney to present that any of them failed to present?
No.
Are you satisfied with all of your attorneys up and until this point?
Very.
Is there anything that you would like to bring to my attention at this time?
No, Your Honor.
Okay, all right. I did receive the proposed jury instructions this morning. I'll look at them during the lunch hour, and after the state concludes their rebuttal case, we can proceed with addressing those. Mr. Beck, yes, sir.
No, the defense did not receive the red line copies that the court discussed yesterday. I don't know if those were sent or not.
I emailed Ms. Barrios last night. Once we got out of court, I'll send them to everyone this morning. Just give me a moment, and I'll get those out right now. Is there anyone else? The email correspondence that I have is Mr. Owens' email, Ms. Andrews' email, Mr. Cacciatore's email. Is there anyone else that they need to be sent to from the defense side?
We'll pass them around.
Okay, all right, very good. All right. Can we go ahead and bring in our panel? State.
Yes, Your Honor.
Defense?
Yes.
All right, let's stand and bring in our panel, please. State, you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes, I do.
All right, thank you. Y'all can be seated. Good morning, members of the jury. Welcome back to 12 Alpha in the Orange County Courthouse. If you could, just raise your hands to confirm that you complied with the court's instructions last night during the break. I thank you. Record will reflect that all jurors have raised their hands. We're going to have a little bit of additional evidence presented by the defense this morning, and then we'll go from there, okay? All right, thank you very much. Mr. Owens, you may proceed, sir.
Judge, at this time, I would move to introduce defense identification exhibit AB into evidence.
No objection to AB or AC.
What was pre-marked as defense AB will be received into evidence without objection as defense 19. And if you could just identify AC for the record, sir.
Judge, at this time, I would like to move defense identification AC into evidence.
Hearing no objection from the state, what was pre-marked as defense AC will be received into evidence without objection as defense 20.
And Judge, I would like to publish these to the jury and allow them to take their time and pass these down to...
You may proceed.
The first is defense exhibit 19. Just review it and pass it down. Next document is defense exhibit 20.
They are, Rogue. They're actually going to rest this morning, and then the state will be able to start their rebuttal.
Thank you, members of the jury.
Owens is just going to enter a couple of the no contact orders into evidence, and then he's going to
Mr. Owens,
rest.
any other additional witnesses, evidence, or testimony, sir?
No, sir, on behalf of Sarah Boone, the defense rep.
Thank you. Defense, or state, are
There
you
you go.
intending on putting on a rebuttal case?
There we go.
Yes, Your Honor.
You may proceed, sir.
Here we go, Rogue. Let's do this.
Please swear or affirm that
Good Lord, you see the stack of papers she's got there?
the truth of what you got. I do.
Doctor, good morning. Could you state and spell your name for the record for us?
My name is Tony Antio, and I am W-E-R-N-E-R.
Oh, thank you.
Did you see
may
that
be seated.
stack of books and papers she brought in?
Good morning, ma'am.
She's like, I have your DSM-5.
I'm employed at Meridian Behavioral Health Care in Gainesville, Florida.
And what services do you render there?
I'm their chief medical officer.
And can you tell the jury what your educational background is?
Yes. So I graduated with an undergraduate degree at the University of South Florida in chemistry. I then attended medical school at American University of the Caribbean. I did a residency in psychiatry at Connecticut Valley Hospital in Connecticut under the auspices of Yale University. I then came back to Florida and did a fellowship 1 year in forensic psychiatry at the University of Florida.
And since your educational background, what have you been doing professionally?
Yes, so I'm a licensed physician in Florida. I am board certified in general psychiatry and forensic psychiatry. I was initially employed on faculty at the University of Florida from 1998 through 2015. I retired there as the vice chairman of the Department of Psychiatry and the director of the Forensic Institute. I then went to work as the chief medical officer at Meridian Behavioral Health Care, which is a community mental health center.
What is psychiatry?
So psychiatry is the treatment of mental health disorders.
And what is forensic psychiatry?
Forensic psychiatry is the interplay of psychiatry and the law, so anywhere where psychiatry intersects with legal issues.
What is the difference, if any, between a psychiatrist and a psychologist?
So a psychiatrist has gone to medical school, where a psychologist has not.
And as a licensed physician, are you able to prescribe medication?
Yes, I am.
In the course of practicing medicine as a psychiatrist, do psychiatrists prescribe medication to treat mental disorders?
Yes, we do.
And when did you begin your work as a forensic psychiatrist as opposed to working at the faculty at the University of Florida, or was that concurrent?
In 1996 in the state of Connecticut, while I was doing my training at Yale University, I testified for the first time as an expert witness in the state of Connecticut.
And over the course of your career, have you done forensic psychiatric evaluations?
I have,
Approximately how many?
thousands of times.
And does this include on matters such as competence?
Yes, it does.
And does it, just explain briefly to the jury, what does that mean, legal competence?
So competence is, do they understand the legal process? Do they understand who the different players are in the courtroom, who's on their side, who's not on their side, what they're charged with, what the possible penalties are, what the possible plea options are.
And have you ever done any forensic evaluations about insanity?
I have. I've done sanity at the time of the crime, and also I've been appointed by the governor of the state of Florida to do sanity for execution.
And have you ever been involved in working as a forensic psychiatrist involving the subject matter of battered spouse syndrome?
I have.
Can you describe your experience in that area for the jury?
I've been asked to do evaluations by the prosecution and defense several times with regards to, and it's come up in different cases, criminal cases with regards to intimate partner violence.
And does all violent episodes within a relationship result in something that we are describing as battered spouse syndrome?
No.
And I see there is a book in front of you. What book is in front of you?
Yes. So this is the Diagnostic Statistical Manual, and this is the 5th edition text revision, which is the most current edition.
Is battered spouse syndrome in there as a diagnosis?
No, it is not.
And where, if anywhere, does it fit into any of the categories within the DSM-5 TR?
It would come under one of the trauma categories, most specifically under most likely post-traumatic stress disorder.
Can you describe for the jury what post-traumatic stress disorder is?
So this is a disorder that's recognized under the DSM for individuals who have suffered a traumatic event, and then they have re-experiencing of the traumatic event. They have different symptoms besides re-experiencing, such as hyperarousal, and also avoidance of triggers or symptoms, things that would trigger a response to it.
Are there any agreed upon criteria within the relevant forensic psychiatric and forensic psychological communities about battered spouse syndrome?
There are.
And what would those be?
So it's again, having experienced a trauma, repeatedly, violence within an intimate relationship, and then having symptoms secondary to that, avoidance, so tiptoeing around, trying to avoid recreating the violence.
And if a person experiences an environmental stimuli, something happens to them, another person does or says something to them, is their subjective reaction what is defined as whether there's trauma present or not?
I'm not sure I understand the question.
Let me rephrase it.
You can rephrase.
You described there's a difference between experiencing a violent relationship and whether or not that person is going to experience trauma from those behaviors they witness and experience. Is that fair?
Yes.
Now I've lost my train of thought. Is it fair to say that an experience that a person has, whether or not that person believes it's traumatic, is a subjective experience?
Yes, each individual is different, and so each individual is going to take that experience differently.
Can hypothetically a couple be involved in a violent relationship for a number of years, even 3.5 years, and battered spouse syndrome not necessarily apply to either or both of them?
Yes, that's correct.
Can you explain that?
So again, each individual is different. So one individual may develop the symptoms of battered spouse syndrome, and one individual may not under the same exact circumstances, just depending on their makeup and what they've experienced in their background and their biological makeup.
And is there a cycle of violence that is sometimes used to describe battered spouse syndrome?
There is.
Can you describe that?
There is. So there's the initial, there's kind of a tension buildup section where you feel the kind of tension building up, and the individual can feel kind of the incident coming, and then there's the actual incident of violence. And then following the incident of violence, there's a honeymoon phase, what they call the honeymoon phase, and that's the third phase, where the individual who created the violence attempts to make up to the victim and recreate kind of the relationship and pull them back in. And then it starts all over again where you feel the kind of tension start building up again to the incidents of violence.
Does abuse have to come in the form of physical or sexual violence?
No.
Can you explain your answer?
So it can also come in ways of coercion. It can come in ways of control, such as financial. So if an individual controls another individual financially or controls their ability to drive or go out, their ability to be around their other family members or friends, kind of isolates them from other individuals, controls their ability to work, so controls their ability to make money or access the funds, so they can control them in any number of ways.
Is this kind of about like an inequitable power dynamic in the relationship?
Yes, absolutely.
Can a man be on the receiving end of emotional or physical or sexual trauma and potentially experience, strike that. Can a man be on the receiving end of verbal, harsh words, physical violence, or sexual violence and end up having the syndrome of battered spouse syndrome?
Yes, it crosses all boundaries, and we see it in all types of relationships, whether it be heterosexual or homosexual relationships. We see it cross all boundaries.
And can this element of control come from controlling personal items such as identification papers?
Yes, absolutely.
Can control potentially, hypothetically, come from partner A gifting partner B an item, but still considering that item partner A's because he or she paid for it, even though it was a gift?
Yes.
And in this particular case, were you asked to do an evaluation of Sarah Boone?
Yes,
Do you see Ms. Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's sitting at a table there wearing a dark suit and a pinkish top.
May the record reflect she's identified the defendant?
Record will so reflect.
What date did you have an evaluation of Ms. Boone?
It was early in October, I believe October 2nd.
And this was at the request of the state of Florida
Yes, it was.
and subject to a court order?
Yes.
And who was present for this evaluation?
The defense and the prosecution.
All right. Tell us about the evaluation with Ms. Boone. What do you do first?
So I met with Ms. Boone at the jail in a conference room. Again, the prosecution was there and her attorney. I met with her for approximately 2.5 hours, just under 2.5 hours. I introduced myself and explained that the interview would not be confidential, that I would be coming to court if asked to share my opinions. And she agreed to participate. I then start out with just general information, so getting to know her, date of birth, kind of background information, who her parents are, childhood. I go through her educational background, her work background, her marital background. I go through health, psychiatric background, any substance use issues. I do a mental status examination.
Can I stop you there?
Yeah.
Elaborate further on that.
So a mental status examination is just questions to determine kind of memory and cognition, kind of how their thought process is, how they're thinking. Are they able to kind of fluidly think through processes?
All right, go on after that.
And then I transitioned from there into walking through the incident that happened with her.
All right, what did she indicate occurred on February 23rd, 2020 to you?
All right, is it all right if I refer to my notes just to make?
Just, if you need them to refresh your memory, please do so, but don't read from them. Just let us know.
So she had a difficult time recalling what time they actually woke up that day. Initially, she said in the morning, and then she said she wasn't even sure that it was in the morning. She said that they both wanted to drink, but that she asked that they could clean the house first instead, and that they did some vacuuming and cleaning. They had a half a bottle of wine left over from the day before that they drank. She felt about 4 o'clock in the afternoon. They drank that out on the back porch. And she described that they had kind of 2 beach chairs out there and a dartboard, and that they kind of hung out there a lot on the back porch, spent time out there. They did a puzzle out there. And completed that, and then did some kind of artwork. She felt like he was getting frustrated thinking about his life, that he had lost his job. And so she encouraged him to call his daughters, although she knew that that they did not like to talk to him when he was drinking. So I'm not sure why she had encouraged him to call them at that point, because they were already drinking. And she also at some point encouraged him to call his brother, because she wanted him to explain to his brother that he had pulled her down the stairs the night before, although that didn't happen. He didn't explain that to the brother, and according to her. And then at some point, they went and got another bottle of wine and some cigarettes from the grocery store and continued to drink. And then they were inside the house, and then he, I guess, tagged her at some point and said, "Tag, you're it," which indicated that they were going to play hide and seek. And she said she went upstairs and hid in the shower and waited for him to come, and he never came upstairs. Excuse me. And so she eventually came out of the shower to look for him, and as she was coming down the stairs, she said she saw him slipping into a suitcase, which was on the living room floor, that they had put out because they were going to donate it. And, sorry. And so she went downstairs and indicated that she had found him, and they were kind of laughing, and she zipped the suitcase up, and they continued to laugh, she said, at that point. And they were having a good time and laughing and enjoying themselves and having a good time. And she said, and then she became angry. And she said she remembered what it felt like when he was choking her, and she became angry.
What did she do after she became angry?
I'm going to refer to my notes at this point.
To refresh your memory, just
Yes.
put them down and then tell us what you remember.
She said that she shook the suitcase and that she lost control of it and it flipped.
And then what happened?
Then she said that he stuck 2 fingers out, and her son's baseball bat was sitting there, and she picked the bat up and hit his hand.
Then what happened?
And then she went upstairs and waited for him to come upstairs.
All right. Alcohol. Can you
Okay.
tell us
Okay,
what
Sarah.
you know about the effects as a medical doctor of ethanol or alcohol on a human body?
Yes. So it causes intoxication, as we all know, and it causes disinhibition. It works on the frontal lobe of the brain and allows us to do things that we wouldn't normally do. It disinhibits us.
And in the course of your practice, have you ever come across a diagnosis of alcohol abuse disorder?
Yes.
And what is that?
Well, alcohol abuse is an old disorder, so we used to use alcohol dependence and alcohol abuse. It's now been combined in the DSM-5. In the DSM-5 TR, it's alcohol use disorder.
In considering what a patient or a client or somebody that you've been asked to evaluate by a government entity, do you take into account that person who's relaying the history to you's consumption of alcohol at the time of the history that they're given?
Yes.
Why is that?
Because again, it affects their behavior and their actions.
Does alcohol have any effect on a person's memory?
It can.
What, if any, relationship is there between acute alcohol use or acute alcohol intoxication and battered spouse syndrome?
Again, it can affect your memory, it can affect your reactions, it can affect your response to different things.
Does the disinhibitory nature of alcohol strengthen, weaken, or have no effect on battered spouse syndrome?
It would depend on each individual again.
Generally speaking, it is important as an evaluator to get as much information as possible before rendering an opinion, such as diagnosing somebody with something out of the DSM-5 TR or battered spouse syndrome.
Yes.
In this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening?
I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change.
And what was your opinion?
My opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
And specifically talking about...
Judge, people could approach the bench.
Yes.
So I have a question about the half a bottle of wine that was in the refrigerator. Remember, she said that about 4 o'clock just now on the stand, she said that Sarah told her at about 4 o'clock they drank that half a bottle of wine that they had from the night before. Didn't she say earlier that they didn't drink that? I mean, I would have assumed she had if they would have, but, yeah. I don't know, folks. Do you think, who was it? Was it Rogue that said that earlier? Yeah, Rogue said, get Brian to say, what a violent drunk she was. Do you think that they will call Brian back? I wonder if they will. See, Patricia, I thought that we had said that she had said they didn't drink it, but we in the chat were like, yeah, right, Sarah. You know you drank that half a bottle of wine. And that she probably drove drunk because we thought she drank that bottle of wine. I don't remember. I thought she said that they didn't drink it, but I don't know. Yeah, the cotton mouth. Yep, Cotton mouth. I think we're behind like a few seconds, a couple minutes maybe. Okay, now we're in real time. You think they'll call Brian? Brian. Oh, I'd hate to be your cellmate too. Can you imagine? Ugh, God. I don't know, Patricia. I don't know why, but I think that she thinks he'll, she probably thinks he worships the ground she walks on. Let's be honest. Right? Ugh. They're going to have to come on. They're gonna have to hurry up. I have 0 patience today. 0. Yeah, I think so too. He's always been her savior, so to speak. Oh, they're really hammering it out over there on that sidebar. Sidebar City. Wow. Oh, what is her necklace of? Can anybody make that out what her necklace is? Not the pearls, but the... Looks like diamonds or silver or something. I can't make out what that is. The light caught it just right and it twinkled. She's like, hurry up, y'all. Come on. Let's get this over with. Is it an anchor? I can't tell if it looks like an anchor with a cross in the middle. I can't tell what that is. I can't tell. Hello, Mickey Jer. Hello, Kel. Hi, ladies. Good morning, good morning.
Member Members of the jury, thank you so much for your patience. I have a matter I have to discuss with counsel outside of y'all's presence. It may
Oh,
take
my
a little
God.
bit more time than just our conference up here, and we don't want to have y'all just hanging out waiting for us to figure out what we're going to do next. So I appreciate your patience. We're going to excuse you to the deliberation room at this time. Please do not conduct any independent investigation or research as to the person, places, things, or charge involved, and do not have any conversations amongst yourselves or anyone else about those things, and we'll bring you back in as promptly as possible. Thank you. Y'all can be seated. Thank you. Mr. Owens, if you can find me that portion of the transcript that we were addressing as to additional opinions and other depositions and anything in Dr. Warner's deposition that you believe we need to address regarding this opinion as it relates to PTSD.
Well, and Judge, it applied to every opinion she was going to express. It started on page 37, line 24. As it relates to Sarah Boone, do you have any diagnosis as it relates to her? And then 38 is when she started talking about a generalized anxiety disorder, and that she was not for sure whether Sarah Boone had a generalized anxiety disorder versus if it was just an adjustment disorder to being in jail. And then she also mentioned in that same answer that Sarah Boone had some narcissistic personality traits, and that those were my two major diagnoses. And then I questioned her further about that. She explained again on line 17 about general anxiety disorder versus the adjustment disorder, and that I hadn't had time to fully formulate that opinion out. Line 21, I need time to go through my notes and think about it and process it.
Page. We're still on page 38?
38, line 21. I need time to go through my notes, think about it, process it. But I had the other depositions, as you're aware, yesterday, so I had to prepare for those and go through that. So I have not had time to process all my notes. And I said on line 39, well, doctor, I'm trying not to inconvenience you. You know, we're set for trial October 7 for jury selection. Line 6, I anticipate your testimony would be until a little later. So we could discontinue the deposition and then reset it when you've got time to review. Because obviously I'm not going to want to take your deposition and you have other opinions that are not going to be covered. And then I asked, looks like Mr. J asked, what's your position? He said, conducting discovery after the jury trial starts is completely unacceptable to me. So that's my position. If she needs to issue a supplemental report, or if there has become a need for a second deposition, then we can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once jury is sworn and jeopardy attaches. And I say on line 23 of page 39, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnoses after she has had more time to think, review the paperwork, then obviously that creates an issue. And then she said, but if that happens, I can bring that forward, and then you can add to your deposition at that point, if my opinions change after having reviewed further. And I referred to Mr. J. Page 9 of 40, Mr. J says, I think we plow ahead. This is our time with her. Court reporter's prepared to give us a transcript by the end of the week. Something needs to be amended.
End of the weekend.
End of the weekend. If something needs to be amended, then she can A, issue a report. B, if we need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition today that is set for 3 hours and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. Then I respond on page 40, line 23. I'm not suggesting that, Mr. J. I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnosis or opinions. Mr. J responds on line 4. Okay. What I'm understanding her to say is right now, there has been a previous diagnosis of an adjustment disorder in some of the records, and she just needs to review her records to see if she thinks that is the best diagnosis that she would give as opposed to a generalized anxiety disorder. And then the witness says, you essentially flipped that, Mr. J, upside down. You got that backwards. So we go on to page 42. Line 1, Mr. Owens, I agree. And Dr. Werner, just let the state attorney know.
Okay, but we're skipping a massive portion of 41
Okay.
that addresses specifically opinions
Let me go back.
as it relates to generalized anxiety disorder.
Okay, the witness starts on line 15. So she's saying she has the generalized anxiety disorder, and I'm saying I want to review it more. Because Sarah Boone had disclosed to the doctor that she had been previously diagnosed with a generalized anxiety disorder. And so the Dr. Werner was considering that admission, but she was saying, I want to review it more to see if I think it's more of an adjustment disorder to being in jail, Judge, to being in the correctional setting right now, and that the stressors that she is under right now as opposed to a generalized anxiety disorder. So Mr. J says on line 22, okay, so on this topic, if something new comes up, then we can address it. But if you have other topics to depose her on, then I suggest we go on. And then page 42, line 1, that's when I say, I agree, and Dr. Werner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend, or whatnot, and formulate any other opinions, just let the state attorney know, and I will address it.
We'll address it.
And we'll address it. Line 7, the witness, Dr. Werner says absolutely. And then, do you want me to continue reading, or?
If there's portions you want to highlight for me, I mean, I have the transcript, I'm following along with you.
That was the general understanding that we had about all diagnoses, all opinions that she may have. And so she starts talking about the mental status exam that she gave her, and then she page 43, line A, she said she has narcissistic personality disorder traits. Or I asked that question, no? That's how she answered. She goes through a little bit of that. And then paraphrasing, she talks about the grandiose component or criteria that she met. And then on page 45, I asked her what other criteria, on line 1, would tend to indicate that she was a narcissist. And the answer by Dr. Werner, I didn't say that she was. I said that she has narcissistic traits. And that was the examples. That was,
Excuse me for interrupting, but can we lasso this back into?
I understand that's what the depot reflects, but the non-objection which led to objection pertains to an opinion specifically about post-traumatic stress disorder. At this time, no opinion is being referenced, nor does the call of the question pertain to narcissistic personality traits or a diagnosis of narcissism. The question pertains to PTSD.
all right, page 46. Line 1, question, okay. Do you feel like she suffers from post-traumatic stress disorder? Line 3, answer. She didn't give me criteria with regards to that. She discussed having fear and anxiety of his family and fear that they would come into the jail or have someone else come into the jail and harm her. She talked about that. And she spoke about, having recollections, remembering abuse from George during the evaluation. Question 13, line 13, on 46. But you don't believe that she suffers from post-traumatic stress disorder, in your opinion? Answer, line 15, no. I would have to look back through my notes to see if she fully met the criteria. Question, line 17, can you explain why you don't think she suffers from post-traumatic stress disorder? Answer, line 19, no. I didn't say one way or the other. I would have to look back through my notes for that. Line 21, question, is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? Line 24, answer, I may. Number 25, question, okay, and that's something you will let the lawyers know about if that changes? Answer, line 2 of page 47, yes. That's specific to the post-traumatic stress disorder.
Okay.
So at the time of this deposition, when I asked her specifically,
So what's the legal objection? What are the legal grounds of the objection?
I would not take that deposition, Judge. When she said, I have not had time sufficiently to answer these questions, these diagnoses, these opinions, if this wasn't set for a definitive date that you had already told me it's not going to be continued, I would refuse to take that deposition. But under the promises from the state,
What
I
are the
will be notified of any changes.
legal grounds of your objection? I'm familiar with the background. I'm familiar with the time frame. I'm familiar with all the dates and the depots and the coordination and everything we had to do to get this all teed up before trial. What are the legal grounds of your objection? I understand the backdrop.
I mean, I don't know if there's a legal ground other than we had an agreement as attorneys, as parties, that I would be notified of a change of opinion and I would be allowed to take a second deposition. That's the
You
only
don't
thing
know
I
that there's a
to
legal
object to.
ground. Okay,
Because
that means
I was
there's
not
not a
given that
legal ground.
opportunity, Which was an agreement between the parties.
Response.
Judge, I don't appreciate the implications that they're making. What I would proffer with this witness is, we spoke yesterday. I asked her if she had any change in her opinion about any of the diagnoses. She said no. And I asked, well then, my position, my understanding of her position is that it doesn't matter whether she had PTSD or not, because what Ms. Boone said at the time was that she zipped Mr. Torres up into the suitcase. They were both laughing, and once he was already secured in the suitcase, she became angry and then did all the things that she did. My expected answers from the doctor, based on a very brief conversation yesterday and this morning, was that if I asked her whether or not PTSD or BSS had anything to do with this particular case, that her answer would be, it doesn't matter because of what she stated happened. I'm not asking her about her diagnosis of PTSD. I'm not going to be going into narcissism. I'm not going to go into whether or not she ever delineated the difference between adjustment disorder or anxiety, because my understanding of what she told me was that none of this matters. None of this matters because of what she said to us during the evaluation.
But the question was, and I may have to ask Madam Court Reporter to read it back, but my memory of what the question was is, have you formulated an opinion with regard to PTSD?
And my expected answer was, it doesn't matter because of what she said during the evaluation.
Okay. Unfortunately, that was not the answer that came from the witness. The answer was a
But that's not
definitive
the
no.
attorney's fault.
I'm not casting blame. I'm just going back over of what was asked and what was said. Okay.
Yes.
Judge, and that's his position, that post-traumatic stress disorder, that doesn't apply in this case, and that he, I'm sure, reflected his opinion to the expert. But that doesn't mean that that's my opinion, that post-traumatic stress does not apply.
That's irrelevant for the purposes of this argument.
Well, their discussions and him feeling like it didn't apply.
Okay, as an officer of the court, he just told me he spoke to the expert yesterday and the opinions hadn't changed. And the opinion that was offered at the deposition was, I'm not sure. And based on what he had proffered as to what he expected the answer to be, the answer was not going to be any different. It's not applicable, it doesn't matter, because of what she told me. That's unfortunately not the answer that was given. So what is it that you're asking me to do at this time, Mr. Owens?
I'm asking, I don't know if we need to proffer the entire testimony of this witness, because opinions and diagnoses have apparently changed. I think I have a right to take a second deposition before she testifies.
What other opinions, Mr. J, if any, are going to be offered by Dr. Warner?
Can I just proffer?
Yes.
All right, you've been present for all this hearing, yes, doctor?
Yes.
Am I misrepresenting any of our conversations?
No.
All right. And so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of the case as the defendant relayed them to you, what would be your answer?
That it's not related to the incident as she reported it.
Okay. And if I ask you, therefore, if there were any prior instances of violence, would that change your opinion? What would your answer be?
No.
And if you reviewed any other materials, would that change your opinion?
Oh,
based
hey,
on what
Melinda,
she
happy
told you about what
Thursday.
happened that evening?
No.
That's it.
Judge,
I agree,
number one, she's
Kel.
given a legal opinion. Number two, it's a discovery violation.
What is the legal opinion?
That post-traumatic stress disorder doesn't apply in this case.
Dr. Harper testified it did, and that's what experts do.
I would like to have known that, and that was going to be her opinion before today.
That's not a change in testimony.
Oh, he got mad and
Where
sat
is
down
that
and
a
crossed
change
his
in
arms.
You're going to
deposition?
have to read the whole transcript. I asked.
No. This is a 87-page transcript. You're objecting. You have the burden to establish your objection.
Give me a minute. I'll read through it and find where I asked her.
I mean, this isn't the first time I've looked at this deposition. The state provided it to me when we had the hearing on whether or not battered spouse would be permitted. And the state provided specific highlights for me to look at. At no point in time did the defense say, look at this, look at this, look at this, in her deposition when we had that hearing. So other than what's being provided to me right now and what's been testified to this morning, I don't know what opinions she has. All I know in coming into today is what the basis of her opinion was, specifically with regard to any of the statements that Ms. Boone had provided, which was the whole crux of the state's motion to prevent battered spouse from coming into evidence.
Judge, if you look at page 66, line 20. Let me know when you're there, Judge.
Hang on. Yes, sir.
Page 66, line 20, question. Okay, so other than the couple of hours that you intend to maybe reflect on your notes and anything else, any other work that you intend to do on this case? Answer 23, no, sir. Not that I'm aware of. Line 24, question. And you've expressed all your opinions, at least generally here today. Answer, page 67, line 1, yes, sir. Question. Then I go into fees. Then on 67, line 7, question, just double dog sure. You admit that you have no other opinions other than the ones you've expressed here today. Line 10, answer, that I've been asked about. If I'm asked something else, that I'll offer it. Number 12, question, and you've been provided all the resources you need to rely on and express your opinions. Line 14, answer. I have based an opinion on the resources that I've been provided. If there's other things out there to be provided that may or may not change my opinion. I believe it's a discovery violation because I should have been notified that there was going to be a change in opinions here today. And we had an agreement that I was going to be allowed to retake the deposition and not be ambushed in the middle of the trial with a new opinion.
What new opinions are different based on what Mr. J proffered the testimony is going to be.
I'd have to ask Madam Clerk to reread the question and the answer from the expert. It's been so long now.
Madam Clerk, or Madam Court Reporter, are you able to reread the portion of the proffer as to what Mr. J asked of the witness? Absolutely. Of course. Court's going to step off for a moment while Madam Court Reporter is able to provide that reading.
Lord have mercy. He is fishing Kel. I think he probably feels like he's only got so many straws left. You know what I'm saying? And he's wanting to pull all the straws. Like, it's winding down, and he feels like if he's got a chance at winning this, he's got to pull any and every chance that he has. And I think the stalling tactic, he's stalling to give himself more time to come up with stuff to knock the prosecution back off their feet. You know what I'm saying? Yeah. He's trying to play chess. The judge is like, I'm going to go. I got to pee. And I'm going to go pee while the court reporter is looking for blah, blah, blah. While she's looking for blah, blah, blah. I would say Friday. I would say that the jury will probably have the case tomorrow. And I don't think it's going to take them long. Do you guys? I mean, what do you guys think? Do you think the jury's going to be like take a long time, or do you think that they'll take 3 or 4 hours and have it done? Update on the Ferris trial, by the way. We're currently watching the clock. They're waiting on a witness. I'm just anticipating, I'm excited for the field trip they get to take today. Hey, good morning, India. What did you miss? A poop show. That's what you missed. So basically, the defense rested. The prosecution started their rebuttal with psychologist on the stand, basically tearing apart Sarah's defense of battered spouse and all that jazz. And Owens, her attorney, Sarah's attorney, is like doing every little thing he can to pick it apart and throw stuff out. So. Kel said, I think it'll take a few hours. Patricia says, since it's only a jury of 6 and not 12, I think it will be fast. 6 will agree pretty quickly, I think. Yeah, that's a good point. I always forget that they have 6 people instead of 12. I always forget that part. What else are you guys following besides Boone? Is there any other cases that you guys are following? Put them in the chat. Let me know what cases or trials you're following besides Boone. Not necessarily just trials, but, any other cases that you are watching. Right, Gail. Delphi, of course. India, what is going on with that one? The Quentin Nixon. What's up with that? I haven't seen or heard anything on that case. On that trial, I mean, honestly, we kind of dipped out on it, but I feel like there was something going on, I don't remember if they ever finished it. Henny said she thinks it'll take 48 hours. $48, Henny? Oh, wait a minute. Are you talking about the show? I'm so sorry. Sometimes my brain just does not work right. Henny's like, I'm talking about the TV, the show. I'm sorry. I was like, 48 hours? Really? God. So I'm sorry. Gail said, after the 2-year covering and all the Delphi stuff, I don't have enough hours in the day for anything else. You guys know that they're saying that they're going to have... I haven't heard any updates today, but they may be doing a resentencing for the Menendez brothers. They said by the end of the week. I don't know. But, yeah, I thought you did, Henny. But then whenever you said 48 hours, I was like, wait, she said a short time. 48 hours ain't a short time. But has anybody heard anything on the Menendez brothers? Like, I've just seen headlines. I haven't seen anything, yeah, I don't know what's going on, Gil, because they were supposed to have a hearing or something at the end of November. So how are they going to have a resentencing thing by the end of the week? I'm really confused on it. I don't know what's going on. Yeah, India, right? India hops over there to the Ferris trial. She's like, "Hi, good morning." That was me, India, that messaged you, that chatted and said, "Hi, long time no see." Press conference was interesting. The press conference with the family, is that the one you're talking about? Wow, India is really multitasking, ma'am. What do you got? She's like, "I got one phone in my left hand and one phone in my right hand." Ay, ay, ay. Do you think they're telling the truth, the Menendez brothers, about the essay from their dad? I fully believe that. Which reminds me, have you guys seen the allegations against the like CEO or whatever of the Abercrombie and Fitch dude? Ooh, ooh, ooh. Kel said, "Last I heard, a member from the boy band Menudo from the 80s came forward and said that Jose Menendez abused him. I think that has a lot to do with what's going on." Yeah. Yeah. It does. Yeah, so India, there was something I've been seeing on YouTube. It's been like coming through my like recommended videos or whatever. And it says the CEO of Abercrombie and Fitch has been accused of R-wording male models for the brand at some kind of weird wonky parties. And they're kind of saying how similar it is to the Diddy stuff, like with his wonky parties. So, yeah, I don't know. I have no idea if it's true. I just don't know. Gail said she saw the headlines on that CEO but didn't click on it. Yeah, I didn't either. I'm like, ugh, that's awful, but I ain't got the brain power for that right now. Don't have the brain power. The camera's moving. Hopefully that means that they're back. Yes, India, I will be streaming the Brian Koberger trial. Absolutely. 100%. Yes. Yeah. That feels like forever away. It does. It feels like that's years and years from now, but it's next year. I mean, honestly, it'll be here before we know it. Kind of like with Delphi. I mean, we waited and waited and waited for Delphi for forever, and now it's here. You know, it's currently going on. Although we don't get to watch it or hear it. Come on, Judge Cranick. Let's get this show on the road. Owens needs to sit down and just take his L. I'll have to go make myself another cup of coffee. I just had my last little sip. I have some like Swiss Miss hot chocolate packets, but they're not hot chocolate. It's pumpkin spice, and it's made by Swiss Miss. And that sounds really good right now. Like what I do with them is use them as like a creamer in my coffee. I think it was Renee that was in here yesterday, and she said that she was going to brew her some pumpkin coffee. And I'm like, ooh, I forgot that I had that pumpkin spice Swiss Miss. Yum. If you take a little bit, here's the thing, okay? If pumpkin spice is not your jam, you kind of like it, but you're also kind of like, here's what you do. You use your pumpkin spice creamer and then put a little splash of French vanilla in there. And then it's like bomb diggity. Look at me when I say it's bomb diggity. I have my double glasses on. These are for seeing the screen, and these readers are for seeing my phone.
All right, we're back on the record. Case number
In my
2020
chat.
CF 2603, State of Florida versus Sarah Boone. State.
Dave Castro on behalf of the state.
William J. for the state.
Defense.
James Owens for Ms. Boone.
Kevin Beck on behalf of Ms. Boone.
Ms. Boone is seated at counsel's table wearing the same clothing from this morning. Madam Court Reporter, have you had the opportunity to review the transcript as to the proffer of Dr. Werner's testimony?
Yes.
Okay, you may proceed.
By Mr. J, question? You've been present for all of this hearing, yes, doctor? Answer, yes. Question? Am I misrepresenting any of our conversations? Answer, no. Question? All right, so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case and the defendant relayed them to you, what would be your answer? Question? That it's not related to the incident as she reported it. Question? Okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. Question. If you reviewed any of the materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question. All right, that's it.
I don't think that's the very beginning before I objected.
What was asked was to read back the proffer.
I thought I was asking to go back to the very beginning when the question was asked and then her response and my objection to it.
What was specifically asked was to the proffer, because the question before the court
Oh my God,
was whether
Owens.
the proffered opinions are at odds with what was testified to during the course of the deposition. There's the question that was asked and the answer that was given affirmatively provided an opinion as to PTSD. I think Mr. J admits that. Mr. J has advised the court that's not what he was hoping the answer would be. That the answer was supposed to be something different, as identified in the proffer, which is why I had Madam Court Reporter read back the proffer. So the question Mr. Owens posed to you is whether the proffered opinions that Madam Court Reporter just read back to us are different than what was provided in the deposition.
Yes.
How so?
She tended to explain in the proffer some legal reason why it did not apply in her opinion. That was not discussed in any way in the deposition.
Okay, my question is specific as to opinions. Her opinions were as to battered spouse syndrome or post-traumatic stress disorder and their relationship to the case based on the defendant's responses. The answer is not related to the incident as the defendant reported. Those are the opinions, as I understand them based on the proffer, as it relates to battered spouse syndrome and post-traumatic stress disorder.
I think I'd refer to page 46. Line 13 was the question, but you don't believe that she suffers from post-traumatic stress disorder in your opinion. Line 15, the answer is no. I would have to look back through my notes to see if she fully met that criteria. Question 17, can you explain why you don't think she suffers from post-traumatic stress disorder? Line 19, the answer no. I didn't say one way or the other. I would have to look back through my notes for that. Question number 21, is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? 24, I may. 25, okay, and that's something you will let the lawyers know about if that changes. That's on page 47. Line 2, yes. That's fundamentally, substantially, materially different from what she's testified as it relates to post-traumatic stress as it applies in this case.
In the proffer?
Excuse me?
In the proffer? She's not rendering unless I misunderstood the proffer, she's not rendering an opinion on PTSD and whether or not Ms. Boone suffers from it.
Well, she led me to believe that she was trying to decide whether or not Sarah Boone suffered from post-traumatic stress. Now, in the proffer, they're claiming that post-traumatic stress does not apply. I don't know what the initial question was. We haven't had that read back when it was first going on, when a question was asked, and I believe she rendered an opinion. And I, again, like that to be reread back. What the initial question was, what the response was, because it did. I know I objected. I can't even remember it now. But I know I objected because I knew it was inconsistent with.
You asked to approach, and then you explained that the question was it was not something that was framed in the deposition. Multiple times I asked you for a legal objection. And it wasn't until right before or right after we sent the jury out that you provided some legal objection. You know, Madam, if you want Madam Court Reporter to go back and read the question that led us to where we are right now and the answer, I'm totally on board with that. I have a memory of what it was, but nothing like.
Before she does that, can I get the first question of the proffer? If BSS or PTSD has any, can you reread that?
Let's just reread the entire proffer, just so that it's a clear soup to nuts, alpha to the omega, what the proffer was. Madam Court Reporter, if you could be so kind.
Go ahead, Mr.
Yes, ma'am.
By Mr. J, question. You've been present for all of this hearing. Yes, doctor? Answer, yes. Question. Am I misrepresenting any of our conversations? Answer, no. Question. All right. So if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as the defendant relayed them to you, what would be your answer? Answer. That it's not related to the incident as she reported it. Question. Okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. And question, and if you reviewed any of the materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
And then if she could go back to the initial.
Hey, Steph. What do you mean, is she taking a proffer? Is she taking the proffer? Huh? They're talking about the proffer that the lady did outside the presence of the jury. And then Owens is trying to backpedal, and now he's making the court reporter basically go through and find everything. And so everybody in the court is confused at the moment. Ooh, thank you, Steph. Thank you. What did you do? Just upgrade, Steph? Because you were already a member, ma'am. Did you just upgrade? You did. You upgraded to the judge. Look at you being cute. Oh, I'm sorry you're sick. I'm sorry. Was it like a cold or what? Judge Steph, right? Let's give her a little bit of sparkle. Let's give her a little bit of sparkle. Thank you so much, Steph. I love your face. I love your face. Rogue says, Kranick, play nice, everyone, or I will turn this trial around. Right?
Wait on you, please. Go ahead. Sorry. Pay no attention to me. Go ahead. My understanding is it was the question and the answer right before Mr. Owens asked to approach.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
Can you read that for me one more time, please?
The answer?
Both the question and the answer.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
May we please have the previous question as well?
Question, and in this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening? Answer, I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change. Question, what was your opinion?
Mr. Owens?
Number one, that question and answer, she gave a differing opinion than what she gave in her deposition, which, subject to the agreement we had, I should have noticed. Number two, with the proffer, it seems that she's going to find that post-traumatic stress disorder did not apply to the facts as related by Sarah Boone. And that is an opinion that I needed to know about. And I asked throughout this deposition and at the very end some general, if you have any new opinions.
Yeah, Steph, feel better, honey. I'm sorry. I'm sorry. I hope it's not like how I was. Oh my God. I don't know whether I had the flu or COVID, but it was one or the other. So it was not fun at all. Rogue says he started it, talking about Owens, and then Jay's like, did not, did too. Yeah, I can totally see them. And then I can totally see Judge Kranick saying, play nicer. We're going to put the sibling sweater on you too. Kel said, I think I understand what he's saying. So in the deposition, she said she would be open to changing her opinion if more information was received. Now, on the stand, she's saying that she would not. I mean, yeah, he keeps saying that over and over, that she's not saying the same thing as she did. And had he been aware of it, that she was changed her mind, now he doesn't have the opportunity to be prepared to, fix that. So, I totally understand where he's coming from. Steph says, "Oop, been having issues. So I missed most of what you said." Aw. You mean about the flu? I was just saying, I hope it's not the flu or COVID. Because I know I had one or the other. I don't know which one I had, but I hope you feel better. Oh, Steph came in and gifted 10 Crime Cafe memberships. Wow. And then 5 more. You better stop it. Oh my goodness, Steph. Oh my gosh. Thank you so much, Steph. You're cuckoo cachoo, ma'am. Thank you. Good heavens. Hold on. We got to have some more sparkle. 2 more sparkles. Hold on. Let's do this. Honestly, Steph, that's very sweet. Thank you, ma'am. I appreciate it. I love you too. Now I need to know who all got one. Because yeah, I need to go see what all names popped up. Lurkers are being called out, are they, Kel? I can't see it on StreamYard. It tells me that she gifted the memberships, but it doesn't tell me who was gifted. I'll have to go look on the actual channel, YouTube channel chat and see. Oh, Steph says I haven't seen 80% of these names before. That's because all of the regulars have a membership. So, oh, that's cool though. That's cool. All right. Let's get back to Sarah Boone, but thank you so much, Steph. That's very, very sweet of you. I appreciate it. You're something else. Now feel better. No more being sick.
That differs from what you said here today. Please notify the lawyers or words to that effect. So it's an evidentiary issue. I've got a right to be prepared for the trial.
They will.
through
They
discovery,
should.
to know what the witnesses are going to opine. And this is a discovery violation based on 2 things. One, her initial answer to the question that I objected to, and then 2, the proffer is a new opinion. It's a discovery violation. I ask that the witness be stricken.
Any response?
Judge, I think it's clear from my original question that
Ooh.
the intent that I stated was the intent of my question, to get the answer that I intended to get, was what the question was intended to elicit from the witness. As far as the discovery violations and continued attacks, I'm just not I'm not convinced he understands what the answer means or what it's going to be. The answer isn't going to be Ms. Boone didn't have PTSD, hence, therefore, battered spouse syndrome doesn't apply in this case. Mm-hmm. What I believe she's going to say, and what I believe I've been saying she's going to say, based on our conversations, was, irrespective of whether anybody believes Ms. Boone had BSS or PTSD, it is irrelevant because of what Ms. Boone told her happened at the time of the event. That is not a discovery violation. She was specific in saying, if you have any questions you want to ask me, I'll give you an opinion. That is exactly what she said on page 67 of the deposition, in response to a question that starts at line 7. Question, just double dog sure, you admit that you have no other opinions other than the ones you've expressed here today. Answer, that I've been asked about. If I'm asked about something else, that I'll offer it. They didn't ask about the interplay of the facts with the relevance of the syndrome. That's them, not the state.
Any other argument?
The totality, if you read that deposition and all that we talked
I
about.
specifically asked you, Mr. Owens, to point out for me
What?
excuse me, I specifically asked for you to point out specific portions of the deposition that are at odds with either A, the opinion that was previously given, or B, what was proffered to. You have provided me pages 45, 46 of the deposition relating to specific opinions on whether or not Ms. Boone suffers from post-traumatic stress disorder. Are there any other portions of the depo that you would like to point out for me? I am not going to read an 87-page deposition and continue to waste our jurors' time as we try to find a solution for the situation that is now before us. If there are specific portions of this deposition that are at odds with the opinions that have been proffered and or provided so far, I would ask you to direct my attention to them,
Well, the ones that I expressed.
other than what you've already identified.
The ones that I expressed, and that just the understanding that we had, that she, in the pages that I have talked about previously here today, and the pages that I referred to about our agreement, that she was going to let me know if there were any opinions that she had, in addition to the opinions that she gave in the transcript.
Okay. All right, thank you. All right. Any other argument, Mr. Jay?
No, thank you.
Okay, thank you very much. All right, the court has had the opportunity to listen to the proffer as read back by Madam Court Reporter, the read back of the opinion that was previously offered, the portions of the deposition which have been highlighted by the defense specifically pertain to opinions by the defendant as to whether or not the defendant suffers from post-traumatic stress disorder. That opinion is not being offered. The opinion pertains to the relationship of battered spouse syndrome and or PTSD as it relates to the facts of the case as the defendant has relayed them to you, and that they are not related. However, the deposition is identified by the defense, identifies that if there were any additional opinions, that there would be notification. So the court at this point in time, as there has been an alleged discovery violation in accordance with binding precedent by the 6th District Court of Appeal, which is binding on this trial court in Young v. State, 369, Southern 3rd, 1243. At pinpoint 1248, the court is now going to conduct a discovery violation or discovery Richardson hearing. State any other arguments with regard to the elements of a Richardson hearing?
No, sir.
Okay, thank you. Any other arguments with regard to the elements of a Richardson hearing, Mr. Owens?
None other than I understood she did give an opinion about post-traumatic stress in that initial series of questions.
Okay. All right, the court, again, reviewing the proffer and the opinion, finds that the state's violation was inadvertent based on the proffer by the state, which was agreed to by Dr. Werner as to the conversation they had last night, as to the opinions and whether or not that they had changed. However, I do find that that violation is substantial with regard to the opinions based on the testimony in Dr. Werner's deposition that any other additional opinions would be notified to the defense. As it relates to the third category, the effect on the defendant to properly prepare for trial. Although the questions in the deposition as highlighted by the defense so far do not address the opinions being currently offered, I do find that it had some impact on the ability for the defendant to properly prepare for trial. As it relates to the opinion that was previously provided as read back, specifically my opinion was that she did not give enough information to diagnose her with PTSD at the time of the evaluation at the jail. What is your position, if any, with regard to that opinion now that the jury has heard it? Mr. Owens. Because my question is, do you want it struck?
On that issue, we'll address it on cross-examination.
So you do not want it to be struck, and you do not want a curative instruction?
Well, I'm going to question her about post-traumatic stress, so it's going to come out through my cross from the deposition about what she said, and then inconsistent with what she said here today, so I'm going to want to rely on that question or that answer.
Okay, all right. Ms. Boone, have you been paying attention to the questions and answers and the readbacks of both the proffered testimony and the opinion testimony?
Yes.
And are you on board with the strategy not to seek to strike that opinion?
Yes.
Thank you. With regard to the proffered testimony, I'm going to permit now in open court, and I will oversee the deposition for you, Mr. Owens, to inquire as to those opinions.
I'm sorry?
With regard to the proffered opinions, the court will oversee a deposition now, and you may proceed.
Right now?
Yes,
He's like,
with regard
right
to
now?
the proffered opinions. And I believe that will provide a cure for the discovery
Lord have
violation under the
mercy.
Richardson
Lord
violation.
have mercy.
Based on your
It's one thing after
request
another.
not to strike the prior opinion. And since you're going to utilize that on cross, I find that the prejudice is limited. But with regard to the new opinions, I will give you the opportunity to depose her now, curing the prejudice at that point in time. You may proceed.
Dr. Warren,
Yes, sir.
good morning.
Good morning.
At some point, the state attorney notified you that you were to come today.
Correct.
Did you and the state attorney have a discussion about your testimony?
Yes.
When was that discussion?
Briefly last night.
So y'all talked on the phone last night?
Yes.
Have y'all had any discussions since the phone conversation last night?
Briefly this morning.
And how long was the phone conversation?
Less than 5 minutes.
How long was the face-to-face conversation?
Less than 5 minutes.
Did y'all discuss that your testimony would be that you did not have enough information that you gathered from Sarah Boone to form an opinion as to whether or not she suffered from post-traumatic stress disorder?
Correct, that my opinion hadn't changed.
I'm sorry?
Yes, that my opinion hadn't changed, that I didn't have enough information.
Okay. And did the state attorney speak to you about that it didn't matter whether you had an opinion if you didn't feel like the facts that Sarah Boone had given you as it relates to the facts and issue in this case, that you didn't, if you didn't feel like post-traumatic stress even applied, then you could answer that way?
Correct, that was my opinion, correct.
But did he present that to you initially for you to form an opinion about it?
No, my opinion was that it didn't apply because of the way that she described the incident to me.
Was that your opinion back when I took your deposition?
Yes,
When did you form that opinion?
when she described the incident to me.
Why didn't you let us know that was your opinion at the time that I took your deposition?
You didn't ask me about that, sir.
Do you remember me asking you any other opinions that you may have as it relates to this case?
You didn't ask me specifically about that.
I understand that, but you're saying you formed that opinion prior to the deposition, correct?
Yes. The state attorney and I discussed that on the way out of the jail, as a matter of fact.
After the deposition?
No, sir. After the evaluation.
Okay.
On the way out of the jail.
All right, and I
Steph,
asked you, were there
ma'am,
any other opinions that you may express at trial
ma'am,
after you had discussed that with the state attorney prior to the deposition?
thank you.
Is that correct?
Yes.
And so you were aware that I didn't want to be ambushed at trial. I wanted to know any and all opinions that you may
Don't know
be
what to tell,
expressing
what to say,
in the Sarah Boone case.
or too much today, ma'am.
I didn't know what specific information you wanted, sir. That's why you had a deposition.
Thank you.
I answered your questions. I don't know what all information you want me to provide to you.
So because I didn't ask you specifics, you felt like you didn't have to respond specifically.
No, sir, I answered all of your questions. And as I said, I'm happy to answer any questions that I'm asked. I don't know what questions you want me to answer.
But you know that this was a central issue in the case.
Right, Kel? She's spending
Did
her
you
whole
not?
paycheck over here.
Your opinion
Yes.
is relating to a central issue in this case.
Correct?
You're aware Sarah Boone's on trial for murder.
That's
And you had this opinion When I was taking your deposition, and I was asking you specifics about any opinions that you may be expressing in the trial of Sarah Boone, and you did not disclose it,
Well, I told you that I would answer any questions that were asked of me. I have a number of opinions. I know that I don't feel that she's suffering from major depressive disorder. I didn't offer that opinion either. I have a number of opinions.
that's all
Wow.
the questions I have.
He's mad. He's big mad.
Mr. J, anything else?
I'm just making sure he doesn't want to inquire,
This is your opportunity, Mr. Owens.
because that was more just about,
Inquire about what?
This is your opportunity to inquire. You are conducting a deposition. This is your opportunity and your only opportunity to cure any prejudice that we've identified with regard to those proffered opinions as it relates to the relationship of battered spouse syndrome and/or post-traumatic stress disorder as proffered.
The problem is now, Judge, is I've got my expert, and we weren't aware, you know how in these type cases, the experts are allowed to listen to the testimony of the other experts and read the depositions of the other experts. Dr. Warner, were you given the opportunity to read Dr. Harper's deposition?
I was.
I mean, that's standard operating procedure in these type cases, and now I'm taking a deposition on the fly, and then I haven't had a chance to speak with my expert about those opinions and whether or not that would change her opinion. It just puts me in a very difficult situation, but if I'm ordered to continue the deposition, I will.
That's your decision. It's not an order. I'm just saying that this is the opportunity to cure that Richardson issue. You asked previously to strike the expert. I am disinclined to do that. The case law says that is an extraordinary remedy, one which I am not going to permit.
Dr. Warner, you realize you're in a courtroom,
Yes, sir.
and we're waiting on the jury on the trial of Sarah Boone.
Yes.
Are there any other opinions that you intend to express in this trial that you have not disclosed to me in the deposition, or you have not disclosed here today under oath?
I'm happy to answer any questions that I'm asked.
Are you refusing to answer my question about any other opinions that you intend to express here today as it relates to Sarah Boone, who is on trial for murder in the second degree?
but I'm going to object. The catch-all vague question that Mr. Owens wants to ask this expert witness about any and all opinions she may or may not
Yeah,
have.
how is she supposed to know what the
99
prosecution is going to
attorneys
ask?
Come in here and say that's not how you do depositions with expert witnesses. You have to ask specific questions. Anytime you ask a question like that of an expert, the expert's always going to say, please ask me a specific question.
I heard
And
that,
that's
Rogue.
what she did then. That's what she's doing now. It's unfair and vague to ask somebody, tell me every opinion you have.
Judge,
Yes, sir.
we're in the middle of a trial. She's fixing to testify. She's had conversations with the state attorney. She knows what she's going to be asked in terms of opinions that she's going to express. That's why she's here, to help the jury understand the science that relates to the law and express opinions. I mean, for me to ask, we're playing hide the ball here? In the middle of a trial,
I disagree that there's any hiding of the ball. There's been a proffer that's been read multiple times as to the scope of the opinions regarding to battered spouse syndrome and post-traumatic stress disorder and its relationship to the facts of the case as the defendant represented them. And the answer is they are not relatable to the incident as relayed by the defendant. That is the opinion that have been proffered.
all right, can I continue with my deposition?
Yes, sir.
Dr. Warner, do you recall expressing that you wanted more time to reflect as to whether or not Sarah Boone suffered from post-traumatic stress disorder?
Yes, that I was going to review my notes to see if I had enough information in there to support or negate that.
All right. What additional information would you need for you to express an opinion that she suffered from post-traumatic stress disorder?
So she did not give me information regarding the presence of intrusive symptoms. She didn't give me information regarding persistent avoidance. She didn't give me information regarding alterations in arousal or reactivity.
Anything else?
No.
Would you agree you failed to ask her those questions?
I asked her if there was any other important information that she felt like she needed to share with me at the end of my evaluation, and she said no.
So a catch-all question.
Correct.
Were there any other personality disorders? Isn't that what you do as a psychiatrist? You diagnose an opinion, express opinions about whether people suffer from personality disorders?
Correct.
Are there any other personality disorders that you have formed opinions about Sarah Boone that you intend to express?
No.
So, narcissism, you did not find.
I found narcissistic traits.
In terms of your opinion that she suffers from narcissistic personality disorder.
No, sir, I said narcissistic traits.
Okay. So you don't have an opinion that she suffers from narcissistic personality disorder.
Correct. She displays narcissistic traits.
You expressed an opinion that she suffers from alcohol use syndrome,
Alcohol use disorder.
alcohol use disorder.
Correct.
Is that still your opinion?
Yes, it is.
Anxiety disorder. Is it your opinion she suffers from the anxiety disorder?
No.
Do you recall in your deposition indicating that you felt like she suffered from either anxiety disorder or adjustment disorder?
That's correct.
And you've changed that opinion now?
I'm leaning towards a adjustment disorder secondary to her legal situation.
So you haven't formed an opinion as to whether or not she suffers from general anxiety disorder or adjustment disorder?
Correct.
Hey, Renee. Good morning. Yeah, those gifted memberships came from
You agree that
Steph.
she suffered from trauma as it relates to the domestic violence
Congratulations.
history that she expressed to you from the intimate partner violence with Jorge Torres?
Yes, as reported by her. Yes.
Do you have anything to dispute that?
No.
In your opinion, does she suffer from any form of psychosis?
No.
Is it your opinion that Sarah Boone suffers from acute stress disorder?
No.
Is it your opinion that Sarah Boone suffers from intimate partner violence?
Yes, I think that there is enough history the volatile relationship.
Steph's doing the
between
mostest
two of them.
today. Thank you,
Because of
Steph.
that, do you believe that
Again.
Sarah Boone suffers from battered
Again.
spouse syndrome?
She may meet the criteria for that.
May. So it's possible?
Yeah.
Is that your opinion?
Yes.
Definitively, you can't say?
There's a history of her having that, yes.
So you agree she suffers from battered spouse syndrome?
Yeah.
I believe we've covered anxiety disorder, narcissism, battered spouse syndrome, and alcohol use disorder. Are there any other opinions that you intend to express as it relates to that or any other psychological condition of Sarah Boone?
No.
That's all the questions I have.
Any other arguments at this time?
No, Judge, just the one I've already made.
Okay, all right. The court has conducted its Richardson hearing and made its findings. The court, as previously identified, will not strike the expert, as that remedy is quite draconian, and I will not do so based on the questions that were asked as highlighted by the defense and the opinions that were offered. The specific areas for which opinions are being offered were not inquired into, but the deposition did leave it open that I'll ask questions about any other opinions that I'm asked about or anything that I'm asked during the course of the trial, specifically page 59, 22 through 26 on 1, page 60, lines 11 through 25. So in the abundance of caution, the court has permitted that in-court deposition. Anything else, sir?
No, sir.
State, anything else?
No, sir.
All right, let's go ahead and bring back in our panel and we can...
Before we bring the jury back in, may I approach Mr. Cacciatore on a completely unrelated matter?
Does it need to be on the record or? Okay, go ahead.
We would concede that Detective Copsell and Detective Lowen are not testifying again since they've been here in court this morning.
They're still under defense subpoena.
I
We have
asked,
not,
I asked Mr. Henderson if you guys were calling Detective Capsule again, and he said no.
and we're not, in our defense, our direct defense, is there a possibility that based upon the information the state is going to present today or this afternoon, that we may want to receive or seek sir rebuttal, and possibly through these witnesses? They're under subpoena, and I'm sorry, Mr. Henderson's not here. I've just noticed her presence. Out of an abundance of caution, I think that we need to clarify for the record that they're here listening to.
What's your base? Well, we're off the record. There's no jury here. That's fine. You all stay where you are. What's the basis for your sir rebuttal?
We don't know because I don't know what the state's going to place in a rebuttal. But
That doesn't answer my question. What's the legal basis of a sir rebuttal?
Judicial discretion as to the fairness of the proceeding that the defendant pursued.
Okay. Anything else, Mr. Cacciatore?
No, Your Honor.
Okay. The rule of sequestration is still in full force and effect. Detectives Lowen and Capsule, good morning. I'm going to ask you to be excused from our proceedings and not view them and not have any communication amongst yourselves about testimony that has been previously given or any questions that have been asked or answered, and just keep your separate ways as it relates to this case and any questions or testimony that you intend to give, may give, or have give. And then comply with any instructions that were provided to you by the state regarding the rule of sequestration. Thank you very much. Anything else, Mr. Owens, we need to address?
No.
Anything else, State?
No, Your Honor.
All right, let's bring back in our jury. You can continue your inquiry, sir.
Lord have mercy. This is like pulling teeth today, man. Jeez. He's like, anything else, prosecution, state? No. Anything else, defense? No. Let's bring in the jury. Oh, but wait. One more thing, Judge. God. I guess, Rogue? I'm not sure.
Bless you.
Hey, Miss King. I agree with that, Miss King. I agree. And then she said that she did agree that Sarah had suffered from battered spouse syndrome. And I'm thinking, I bet the prosecution's like, really? Hey, Margaret. Hi. Judge needs a strong cup of coffee. Yeah, him and me both. I'm going to go fix me some. I got none left in my cup.
State, you recognize our jury.
Yes, Your Honor.
That's, you recognize our jury. I thank y'all. You can be seated.
Yeah, she should look
Members of the
worried.
jury, thank you again
Renee.
for your patience. We had some issues I had to address with counsel outside of your presence, and we're going to continue the state's rebuttal case this morning.
Okay,
Again, if
I'm
you
gonna
could
go get
please
a
just
cup of
raise your
coffee.
hands to confirm that you complied with the court's instructions during the break. Record reflect all hands have been raised. Mr. J, you may continue your inquiry, sir.
State would move to strike the last response as non-responsive.
Approach.
Oh my God. I don't even remember what the last response was. And we're back. Yeah, I didn't even make it up out of my chair. I didn't even make it up out of my chair. At this rate, they will be here 2 weeks from now. Steph says, okay, so like, did India and Rogue allow gifted memberships? I don't know. Renee says, true, it's so annoying how the judge has to baby walk Sarah every 5 minutes.
Your objection's overruled.
All right. Irrespective of whether anybody has an opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that, based on your evaluation of Ms. Boone and what she relayed to you about the facts of the case, does PTSD or BSS have any relation?
Objection, that's been asked and answered.
Overruled.
No.
And what particular part of her statements about the incident is that?
The whole part where she's describing the part about playing hide and seek and that they were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him up. They were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or there was an imminent risk of harm that she needed to protect herself.
Can we proceed?
Yes.
This witness is like, I am so done right now. She is so irritated. And you know what? She's probably feeling very irritated anyway and stressed to the max because she sat there and listened through that whole entire rigmarole. Them arguing back and forth. Yeah, her face is like, I am so done. She's like, anything I say, somebody's gonna, have an issue with. I can't even go get a daggone cup of coffee. I just want a cup of coffee. Stephanie, do not make me dox your whole government name. You, ma'am. God. Steph. You're killing me today. I appreciate it. But I'm really bad at, I'm really bad at this. Here, let me give you some more sparkle. You are too generous, ma'am. Oh, did Abigail get one, Gail? Abigail got a membership? Ah, my goodness. You get a membership, and you get a membership, and you get a membership. She's being all Oprah over here. She's something else. She's something else. Lurkers be lurking. Oh, God. India must have, I don't know if India got one or not, but India must have her gifted memberships not turned on or something. Right, Gail. Right, Rogue. Rogue says, I hope when I get called for jury duty, we don't keep getting yo-yoed in and out like this. Aw, Steph. I love that. And I love you. Thank you. That means a lot. The words mean more than the moolah. Just saying. Yeah, Rogue and India, if you don't have your memberships turned on, go turn them on. Unless you have, I think they say a branded account, you can't get a gifted membership, but I don't know if you do or not. You can never look at luggage.
Members of the jury,
The
I have
same
something
way.
I've got to discuss with counsel outside of y'all's presence. Same instruction, please don't conduct any independent investigation or
Oh,
research
my
on the
God.
person, places, thing, or charge involved, and don't have any conversations among yourselves or anyone else with regard to that, and we'll bring you back in as promptly as possible. Thank you.
Rogue. Kel has jury duty. Oh my God. That's exciting. Yeah, this is painful. This is ridiculous. Ugh. They're getting ready to have it
Y'all
out.
can be seated, thank you.
They're getting ready to rip each other apart right now.
Madam Court Reporter, when you're ready.
Stephanie. Thank you, Steph. Somebody explain to India how to do it, because I'm not really sure. It's been too long since I've done it, and things change. Whatever, Margaret. You're beautiful. Steph says now it's like a game. Come on. It's like she's playing the slot machines or something. Click on the gifted membership things and it should ask if you want to allow it. I'm not sure. Does it do anything if you click on the membership things on the like people who have been gifted, or where it says that she's gifted memberships? If it don't, then it may be something where you have to go into your actual account settings and find it that way. No, Margaret, you are not a troll doll, ma'am. I have to have coffee. I'm going to take my phone with me and listen to this because I know that they are getting ready to just, like, beat each other up here in a minute. I'll be right back.
Yes, ma'am. Just go read it from the question, answer, question, objection. Let's just have we can buttress it. Go ahead.
By Mr. J, question, all right. Irrespective of whether anybody has any opinion about whether Ms. Boone is suffering from PTSD or DSS, irrespective of that, based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD or DSS have any relation? Mr. Owens' objection, asked and answered. The court overruled. The witness, no. Question, and what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part about playing hide and seek. They were having a good time, they were laughing. When he got into the suitcase, when she found him, they were enjoying themselves. She zipped him, they were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
Any other argument, Mr. Owens?
That invades the province of the jury. That's a decision whether or not she had imminent risk of harm or perceived an imminent threat is a question for the jury. This expert can express opinions on science, on medicine, but not on the ultimate issue of fact, and explain to the jury that this defense doesn't qualify, that you should rely on me as an expert, and I'm going to make the decision for you, ladies and gentlemen of the jury, by telling you that under the facts expressed to me by Sarah Boone, she was not perceiving an imminent threat at the time.
Response.
It's not an objectionable opinion. It's not an opinion on the ultimate issue. It's an opinion upon the applicability of a particular set of evidence that the testimony that the defense has offered, called battered spouse syndrome, to kind of help explain a portion of the justifiable use of deadly force or non-deadly force instructions. She's not up there saying Ms. Boone was unjustified in doing what she did. She is not saying that justifiable use of force doesn't apply. What she is saying is, in her opinion, based on the facts that she relies on, given by the defendant herself just a couple of weeks ago, that this particular set of testimony and evidence that has been offered through their expert, Dr. Harper, doesn't apply. This is no different than one expert coming in and saying, well, yeah, you can know that the defendant was sane at the time despite his mental illness because he ran from the police, he hid, he concealed evidence, so on and so forth. And therefore, because of those facts, insanity doesn't apply. And a defense expert may come in and say, well, insanity does apply because my client, after stabbing her mother to death, called 911, was speaking unintelligibly and singing, and greeted the officers at the door with a pair of knives and wouldn't drop the knives and was incoherent for 12 hours after the offense. Therefore, based on those facts, the expert says, well, insanity does apply. It's not becoming a lawyer. It's not becoming the juror. It is explaining a particular type of expert testimony, and it just happens to disagree with Dr. Harper's. And Dr. Harper came in and said that BSS does apply and that she was in constant fear. And the reason she's in constant fear is because of all the past episodes and whatnot. It's permissible testimony, Judge.
Any other argument, Mr. Owens?
That's totally wrong. He claims, the prosecutor claims, Dr. Harper came in and said BSS does apply. That's true. But he just got through saying and trying to get the witness to say BSS, it's not to be regarded. Post-traumatic stress is not to be regarded. It doesn't even come into play. Post-traumatic stress disorder, battered spouse syndrome does not even come into play because at the time she was facing, according to this witness, no imminent risk of harm. Therefore, you can discount everything you hear, ladies and gentlemen of the jury, about battered spouse syndrome.
How does that have anything to do with whether or not it's an improper legal opinion under 90.703?
It is. It's the ultimate issue of fact in this case because self-defense has been alleged by the defense. And the issue for this jury is whether or not Sarah Boone had the right to defend herself with force, deadly force or non-deadly force, based on her beliefs and impressions at the time, whether they were reasonable under the jury instructions, under the special jury instructions that are going to be applied for battered spouse syndrome, under the jury instructions under justifiable use of deadly force, whether her perceptions about the threat was imminent and whether it was appropriate or reasonable to act the way she did. This expert is trying to say that she was not facing imminent risk of harm at the time.
Thank you both for your arguments. Court is going to overrule your objection, find that it is not an ultimate issue of fact as addressed by 90.703. The court specifically relies on Dinkins versus State 976 Southern 2nd 660 at pinpoint 661. In that case, a psychologist testifies in the instant case in Dinkins, the psychologist's opinions were not legal conclusions. The psychologist did not opine on the defendant's guilt or innocence. Rather, the psychologist opined only as to whether the victim was, quote, mentally defective, end quote, and capable of consent to intercourse. Although the opinions did go to ultimate issues in the case, Florida law, expressly provides that an expert witness may render such opinion, see section 90.703 Florida statutes, which provides that testimony in the form of an opinion or inference otherwise admissible is not objectionable because it includes an ultimate issue to be decided by the trier of fact. Thus, the jury had the power to accept or reject the opinions and was not bound by such. For those reasons, your objection is overruled.
Madam Court Reporter, I'm just going to ask you to read the question and answer, and I have no further questions of the witness.
Okay, thank you.
I'm sorry?
He's going to have Madam Court Reporter read back the question and the answer, and then he is going to have no other questions for this witness.
I object.
Basis.
It was asked and answered.
Overruled. There was a pending objection. I'm allow the state to re-ask it so it's clear based on that objection.
Judge, it's 11:30. I'm going to be at least an hour for my cross-examination.
We're going to begin your cross-examination after we're done with the state advises the jury in open court. There are no more questions. Let's go ahead and bring back in our panel.
Okay, two things. Steph, stop it. No more gift memberships for Steph. Come back 1 year. Second thing, coffee. Third thing, oh my God, this has got to go. Boone has got to go. And now I want Halloween candy. Renee and Steph talking about Halloween candy in the chat. That's turned off my laptop. Good for you. Good for you. I don't know why India didn't get one. I think India is now the only one that doesn't have one in the chat. She'll get one eventually. But you're coming back in way less than 1 year. Okay. Let's get this jury back in this courtroom, please. And thank you. Coffee. Don't make me get the laptop out again. I would be willing to bet that there's something messed up in one of the, in India's settings. Margaret said, see how you get put on a restriction for a year around here? Yeah. No poll for you, Margaret. Come back 1 year. Gail, I love that one too. No. Steph's going to send Margaret the money to do it for her while she does her polls. Oh, my God.
Defense, you recognize our jury. All right, you may be seated. Thank you. members of the jury, again, if you could raise those hands. Juror number 2, back right, he gets it. All right, thank you all very much. Record reflect, all hands have been raised. State, you may proceed.
Request to read back the question and answer.
Madam Court Reporter.
Please let him do this. Please let him not have to go back out. The gal on the stand is over it.
Question by Mr. J. All right. Irrespective of whether anybody has any opinion about whether Ms. Boone was suffering from PTSD or ESS, irrespective of that, based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD and ESS have any relation? Mr. Owens' objection, asked and answered. The court overruled. The witness, no. Question, in what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part of about playing hide and seek. They were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him, they were still laughing, having had a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
No further questions.
Any cross-examination?
Yeah.
You may proceed, sir.
Steph, I think it's supposed to be like a business account instead of a personal account or something, maybe. Yeah, this court reporter's done too. She's like, I didn't sign up for this.
What all did you consider collaterally as it relates to your opinions you're expressing here today?
I had a number of documents that I reviewed. I'll look at a list. I had the Orange County Sheriff's Office investigation report. I had a transcript of a 2-hour interview of the defendant. I had a
That's the 2-hour interrogation with Detective Lowen and Detective Copson?
It was an interview, yes.
Excuse me?
Yeah.
Okay, go ahead.
It was labeled an interview. Then I had a transcript of a second interview the next day of Ms. Boone. I had medical records from Aspire Health and Advent Health. And then I had some cell phone records. And I also received the deposition of your expert.
The deposition of Dr. Julie Harper?
Yes.
Okay. And did you listen to Dr. Julie Harper's testimony in this trial of Sarah Boone?
No.
Do you agree you have a right to do that?
Yes.
And did you listen to Sarah Boone's testimony in the trial of this case?
No.
You agree you have a right to do that?
Yes.
And you elected not to listen to her testimony before expressing opinions here today?
Overruled.
I did not have time to do that.
You did not have time to do that?
Correct.
She's on trial for murder.
Yes.
Sustained.
You said you considered some text messages from Sarah Boone's phone.
I reviewed them, correct.
Would it be fair to say that of those text messages, they're not necessarily overly relevant?
Objection, any reproach?
Yes.
Ms. King says, I think she has a brand account. I could not figure out how to change mine without losing my account and starting over. And then Ms. King says, but I don't have a business account, but I set this up a long time ago and probably had no idea what I was selecting. Yeah, I'm not sure either. It's kind of the same way with Instagram. Like you can have a personal account or a brand account. But either way, Miss King says, I don't like this doctor. Yeah, there's something about her that I'm not crazy about her either. But I know that she still is just over this. She's ready to get out of there.
regarding these text messages that you were provided, did that inform your opinion that you just expressed about the inapplicability of BSS or PTSD to the facts of this case?
No.
No. Sorry.
Did it apply to your opinion that Sarah Boone suffers from battered spouse syndrome?
No.
Are that information, when you express opinions in court about a patient or about an individual, you rely on your personal assessment as well as the documents and evidence that you're provided and asked to review, are you not?
Correct.
And in this case, your testimony is that you reviewed
Hey,
all
Adam,
that
good morning.
information before you interviewed Sarah Boone for 2.5 hours.
Right, Renee.
On October the 2nd of 2024, 22 days ago.
Correct.
So you had the information,
Yes.
the documents.
I agree, Miss
You read
King.
the documents.
Yes.
You read all the text messages.
Correct.
And you are going to express some opinions here today, are you not?
Correct.
You're going to express some opinions about narcissism, whether or not she had.
Yes.
Yeah, I agree. Yeah, you don't like Sarah is what you meant. I knew what you meant. I knew what you meant. I mean, she is on trial for second degree, but still, I mean, she's on trial for murder, you know? I just don't, I kind of think feel like this doctor is just gonna say what she wants to say, but also, or say what they want her to say, but also the fact that she had said that she agreed that she felt like Sarah did have battered spouse syndrome. I don't know. I'm just kind of like wishy-washy. I'm like, I don't know which side of the fence she's on. But and I've checked out. I've checked out of this whole fiasco the last hour. I'm over the whole thing. Right, Adam? She could have watched Sarah's testimony live here. Gail said, I feel like if she was going to form an opinion on someone that is up for murder, maybe she should have watched Sarah's testimony. Adam said, I mean, half the country watched it, but you didn't have time and you're an expert? Okay. Right. Miss King says, exactly, Adam, and had more foundation for her opinion. Right. Telemed appointment was early, catching up. Oh, yay, Steph. So what did they say? They want you to go in for a test. Yeah, I mean, I'm not on what you guys are saying in the chat. I love it because you're basically saying that Sarah deserves a fair trial, right? And I feel the same way. Everybody deserves a fair trial. QB is the queen of saying that. Even, everyone deserves a fair trial. And if she's, I don't know. I just feel like this isn't a great witness for the prosecution. Just saying. That's all I'm saying. Da, 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 da. Da, 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 da. Miss King says, if I were on the jury, I would discount what this doctor's opinions are and not put any weight to her opinion. Steph, you didn't say what the doctor said about you. She said sinusitis. Postnasal drip is causing the backside stuff. The frog mulch. Oh, God. The frog mulch. Are we serious right now? Gross. Gross. Right, Miss King, there's so much more against Sarah. Like the video. Steph says I clearly am not paying enough attention. Yeah. Right, Gail? She's like, you know what? You know what? If you have any doubt that Margaret is not watching, just let Steph come in and say something. Margaret cannot help herself but coming in and saying, what? What? Renee, okay, you're asking for it, ma'am. You're asking for it, but just know that Steph's name is TMI Steph, okay? So Steph calls the act of number twoing, pooping, making frog logs. Okay? Because she's sick, she doesn't have frog logs. She's got frog mulch because it's, not solid. There you go. You asked for it, Renee, and I gave it to you all the way. We have a lot of poop talk here at the Crime Cafe, too. Just saying. We do. We do have a lot of poop conversations over here. We do. My cat heard Jenny say, what? And replied back. Oh, my God. She has froggy diarrheas. Steph said frog logs are a real thing. They are. You can buy them and put them in your pool, and it's supposed to help the frogs be able to get out of the pool and save their lives versus get hung up in the skimmer basket or whatever, But yeah. She thought they were talking about people having frog poo in their yard. And then it just became a whole thing. It became a whole thing. Margaret left YouTube. Margaret uninstalled YouTube. Margaret left the state. Margaret's gone. Bye. Margaret returned her social devices to the store. Oh my God. Renee said, I used to want to be a pro makeup artist. No one cannot tell me that Sarah is not wearing some very high quality makeup. I'm serious. It's not cheap crap. Girl gets what she wants. I don't know. Right, Gail? Margaret, come back. Margaret, come back. You can blame it all on Steph. Margaret, come back. God, this is a whole sidebar right now, ain't it? Like, what are we even waiting on? I forget.
Objections overruled. You may proceed.
Thank you, Judge. Ma'am, is it fair to say, in your evaluation of Sarah Boone on October the 2nd of 2024, that you felt like the text messages that you received from the state attorney
Objection beyond scope.
Overruled.
are not relevant to your evaluation of Sarah Boone?
Withdraw.
I wasn't sure at the time who actually, I wasn't sure whose phone number it was. In all honesty, we discussed that in the deposition, and I wasn't sure, I have no proof of who actually sent the text, who actually had possession of the phone and put the text, any of the text in.
Well, I was there for the deposition, was I not? Or I appeared by Zoom, did I not?
No, so you were present in person.
Okay, I'm trying to think.
Oh, deposition.
The deposition.
By Zoom, yes.
You appear by Zoom, I appear by Zoom, the state attorney appeared by Zoom.
Yes, that's
And we discussed that these were the phone records from Sarah Boone's phone.
yes.
Okay. And at that time, you said they're not necessarily overly relevant to your evaluation. Did you not say that?
I don't recall specifically. I'm happy to look at it.
Can I approach the witness?
You may.
I have it, if you just refer me to the page.
Just a moment.
You got it?
I do.
Page 14. My question is at line 3. Your answer begins at line 5.
Correct.
And you agree that any,
Finish the law here based on.
Let him finish. Let him finish.
well, I'm going on, I'm going to ask another question about the text messages, Judge.
You just said line 5, approach.
Oh my God. This is never going to end. It's the trial that never ends. It goes on and on, my friends.
Dr. Warner, did that refresh your recollection about our discussions about the text messages in your evaluation?
Yes.
And would you agree that they're not necessarily overly relevant to your evaluation of Sarah Boone?
Correct.
And do you agree that after reviewing all those text messages, that there was nothing that stuck out to you that caused you to pause and feel like they may have some impact on your evaluations of Sarah Boone?
Permission to law here.
Can she answer the question?
Have her answer the question first.
I'm not sure what you're referring to in the deposition.
Page 14, my question is at line 21. Your answer is at line 25.
Correct. And I said no. As I said, it made me aware that they had a volatile relationship.
But my question to you specifically is there anything in the text messages that stuck out to you that caused you to pause and feel like that may have some impact on your evaluations?
No, have a good day at work, Kel. Love you, babe.
Correct.
And you agree your answer is no?
As I said, it made me aware. That's not my complete answer.
Okay, well, let's
I
talk.
can read my
First,
complete
you said no.
As I said, it made me aware that they had a
Ma'am,
volatile
ma'am.
It's not my complete answer.
I know, Dr. Warner, but didn't you say no to me? That was your first sentence, was no.
It's not my complete answer.
I understand. I'm going to let you answer that. But when I asked you if there was anything in the text messages that caused you to pause and it would in some way affect the impact on your evaluation, your answer to me was no.
It's not my complete answer.
I understand. But was your answer not to me no?
Yes, but that is not
All
my
right.
complete
Now,
answer.
at the same time, Dr. Warner, at the same time you expressed that they had a volatile relationship.
That is not the totality of my answer either.
Okay, and I'm going to get to it.
Okay.
But part of your answer was that they had a volatile relationship.
Correct?
And this is in relation to my question about the text messages. You agree?
Yes.
After you said no, you said they had a volatile relationship and that she text messaged calling him an idiot, a fucking idiot, for overdrafting her account.
Correct?
And in those text messages, there was some reference to domestic violence between the two.
Correct.
And that demonstrated to you that they had a violent relationship.
Correct.
And do you not agree that that evidence of a violent, volatile relationship had an effect on you expressing your opinion here today that Sarah Boone suffered from battered spouse syndrome?
Judge, we need to object. We need to approach.
Oh my God, this is getting hairier and hairier by the minute. Good gravy. And the jurors in the Ferris trial are getting ready to go on their field trip. Yes, yes, yes. No, Steph. Or wait, maybe the jury is in there right now. See, I don't even know. They must be because she was just smiling at the jury. See, now I'm confused. I don't know whether we're coming or going. Yeah, they're there. That's who she's smiling at and looking at, talking to. But when Steph said that, I was like, wait, what? All right, Steph. Have a good grocery store trip. Go get your medicine. And then get back home and feel better. Just in another app. Okay. No worries. No worries. Every little thing's gonna be alright. Ferris trial is on break. I'm sitting here looking at Melody with a big legal notepad in her hand right now. Did they say India? I could hear the judge talking in the background, but I have it like the volume way down low. So I don't know how long that they're going to be like traveling. Did he say if the media is going to be there, we get to watch? Like, fill us in. Also, MWF is confusing because I'm like, what's the Monday, Wednesday, Friday stream? Uh-oh, the judge over there on Ferris is sick. Okay, folks, I'll be back in I've been gone for a couple minutes, but I have to go check in over here on the Ferris trial real quick because they're going on a break. And I have to ask the chat over there a couple quick questions. So I will be right back. Continue. Every little thing is going to be all
Members of the
right.
jury,
Yeah.
it is 11:55. At this point in time, we're going to go ahead and take our lunch break. I'm going to give you a similar instruction that I've given you throughout the last couple of days. Give me a moment to pull it back up. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again, bless you, that just as you must not talk about this case face to face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, we're going to be in recess till 1:30, and we'll pick up at that point in time. Thank you so much for your service. Y'all may be seated. State, anything else?
No, Your Honor, thank you.
Defense? No, sir. All right, we'll see you at 1:30. Thank you very much. Court's in recess.
Okay, recess until 1:30. And then over here on Ferris, apparently they're having lunch for 30 minutes and then a road trip. So, I think what I'm going to do is would you guys rather, okay, put a 1 in the chat if you would rather me leave the stream up till 1:30 when they come back, but put the intermission on and music. Like have a whole hour and a half long intermission. Put a 1. Or 2, if you want me to cut the stream and come back at 1:30 with stream number 2. Completely up to you guys. If you want to hang out in the chat, I have to see what's going on over here. And then, yeah. Ooh, camera like dropped. Every little thing is gonna be all right. Sorry, I'm just waiting on the chat, waiting on you guys to let me know what you want. Okay, I got an answer from Miss King and Henny. So 1, if you want to go for a brief not brief, it'd be an hour and a half long intermission. withhold music. Or 2, if you want me to cut the stream and come back for stream number 2 at 1:30. Da 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 da. Okay, cut the stream and come back at 1:30. So that's 2 votes for that. 1 vote for hour and a half long intermission. Ba-da-da-da-dum, ba-da-da-dum, bum. Oh, my phone's in the red. I need to charge it. Hold on a minute. Gail said 2. Oh, I already saw that one. God love. The judge over there in Ferris does not feel good. He is going home after the farm trip and getting under a comforter, he says. I don't like that. India says 2 as well. All right. Steph is going shopping. She is going shopping, right? Okay, well, then that's what we'll do. We'll come back at 1:30. I'll schedule the stream for 1:30, you guys. If you don't get the notification, then just come back to the Crime Cafe channel at 1:30, and we'll start after lunch. Hopefully they get their ish together, because this has been an ish show all freaking day. And I'm over it. Steph is shopping for food, not memberships. I want to be under the comforter too. Oh, I'm sorry, Steph. All right. Okay. I'm going to go ahead and cut it here. We'll come back for part 2 after lunch at 1:30 Eastern. So in about an hour and a half, okay? Make sure to give the video a thumbs up before you leave. #replay if you're watching this later. And if you're new, would love for you to subscribe and click that notification bell. Okay? I'll see you all in a bit. Have a good lunch yourselves. All right. Bye.